LawSikho thorough newspaper analysis for 30th of January 2024. चले आज के एडिटोरियल और एजेंडा की तरफ चलते हैं जहां पे we'll be talking about ASI opinion on Gyanvapi mosque, how the court is likely to review the report which we have taken from the Indian Express. Then as per the agenda, we'll go with the news update and then the legal news update of the day. Now, the editorial section which talk about the archaeological survey of India's opinion on Gyanvapi mosque, and now the ASI was asked to ascertain whether the Gyanvapi mosque was constructed over a pre-existing structure of a Hindu temple, submitted its report to the Varanasi district court in a sealed cover last month. Now, copies of the report were given to both the Hindu litigants who have claimed that the mosque was built on the site of original Kashi Vishwanath temple after its destruction in 17th century. Now, archaeological surveys confirmed that the mosque was built over a pre-existing temple that had a big central chamber and at least one chamber to the north, south, east, and west. Too significant is this report in the ongoing litigation over the Kashi Vishwanath temple and Gyanvapi mosque complex. Now, what is the expert opinion on this? So the 800-year-old ASI report would be considered expert evidence that can be contested in court and need not simply be taken at face value. The parties in the civil suit will bring witness to satisfy who will be cross-examined by the other side. Historians, archaeologists, epigraphists, witness of the facts, and expert witness with religious knowledge will be presented before the court. In the Babri Masjid Ram Janmabhoomi case, the ASI finding on the use of lime surkhi were interpreted differently by two sides. Now, the senior advocate stated that, all the evidences that have been collected will be considered as an expert evidence. The Hindu side relied on the depositions of the archaeological Suraj Bhan, who said that it is correct to say that lime water was found to have been used in 3rd century during the Kushana period in Takshila and Pakistan. Now, the court have to essentially determine first whether the ASI report can be relied upon conclusively, and then what the existence of Hindu temple means to the religious character of the mosque on August 15, 1947. The ASI report from 2003 was cited in the Babri Masjid Ram Janmabhoomi suit, and its 2019 decision, Supreme Court did not completely rely on it. A finding of title cannot be based in law on an archaeological finding which has been arrived by the ASI. Between the 12th century to which the underlying structure is dated and the construction of the mosque in the 16th century, there is an intervening period of 4 centuries and no evidence is available of that particular centuries. Title to the land must be decided on settled principles and applying evidentiary standard which govern a civil trial. Now, first, the preliminary issue of maintainability would be there. Whether such a suit can even be filed will have to be conclusively decided by the Supreme Court. This issue, however, rests on the fate of the Places of Worship Act 1991. Section 3 and 4, which was enacted in the wake of the Rama Janmabhoomi movement in 1991, essentially declared that the religious character of the place of worship shall continue to be same as it was on August 15, 1947. The Gyanvapi District Court has rejected this challenge to the maintainability, and Supreme Court orally observed in 2022 that finding the nature of religious place is not barred under the Act of 1991. Supreme Court is yet to hear the final arguments to decide the preliminary issue of whether the 1991 Act bars even the filing of such plea. Separately, the constitutional challenge regarding the grounds that it introduces an artificial timeline remains pending before the court. In 2019, the Supreme Court indicated that the case could be referred to a larger constitution bench, but the center is yet to file its response. In 2019, the Ayodhya judgment Supreme Court said the 1991 law was a basic feature of the constitution. The state has, by enacting the law, enforced a constitutional commitment and operationalized its constitutional obligation to uphold the equality of all religious and secularism, which is a part of the basic features of the constitution. Non-retrogression is a foundational feature of the fundamental constitutional principle of which secularism is a core component. The Place of Worship Act is thus a legislative intervention which preserves non-retrogression as an essential feature of our secular values. So, the ASI opinion on Gyanvapi Mosque and how court is likely to view the report, we'll see in the coming future. That's all for the today's editorial session. Now, starting with the national news, PM inaugurates Diamond Jubilee celebration of Supreme Court. So, Prime Minister Narendra Modi has inaugurated the Diamond Jubilee celebration of the Honorable Supreme Court of India in Delhi. During the celebration, PM Modi launched Digital Supreme Court Report, that is DGSCR, Digital Courts 2, and then bilingual website for the Supreme Court. The Digital SCR initiative aims to make Supreme Court judgment available to citizens free of cost and in electronic format. And Digital Court 2 under the e-court project focuses on providing electronic court record to district court judges, incorporating AI for real-time transcription. Now, Indian Army gets first woman Subedar. So, renowned trap shooter Preeti Rajak has become Indian Army first woman Subedar following an out-of-the-turn promotion after a silver medal performance at the 19th Asian Games held in Hangzhou in China. She was also the first sportswoman from the shooting discipline to be inducted in the rank of Havildar. Subedar Rajak is currently ranked 6th in India in trap shooting event among women and is preparing for the Paris Olympic 2024. Inaugural edition of India-Saudi Arabia joint military exercise gets underway in Rajasthan. So the inaugural edition of India-Saudi Arabia joint military exercise, that is Sadat Tanseek, which seeks to develop interoperability, bonhomie, and camaraderie between the troops from both the sides, begin in Rajasthan on Monday. The aim of the exercise is to train troops of both sides for joint operation in semi-district terrain under Chapter 7 of the United Nations Charter. Now, Satyabrata Mukherjee, Mithun Chakraborty, Usha Uttam get Padma Bhushan. Former West Bengal BJP President Satyabrata Mukherjee, actor and BJP leader Mithun Chakraborty and singer Usha Uthup have been honored with Padma Bhushan, the third highest civilian award in the country. Now, Mukherjee was the Minister of State of Chemical and Fertilizer and Commerce and Industry in the Atal Bihari Vajpayee government at the center from 1999 to 2004. Mithun Chakraborty started his film journey with Mrinar Sen Mrigya and got the National Award for the Best Actor for it. And pop singer from Bengal, she was born in Mumbai. Usha Uthup started her career as a nightclub singer. Uthup sang for many Bollywood and other language films. She also acted in few movies. Chaliye. Now, AISHE report, Uttar Pradesh leads nation in college density. So, Uttar Pradesh is a state with the most colleges in the nation, according to the recently released All India Survey for Higher Education report. Karnataka and Maharashtra have taken third and second place respectively. UP, there are 30 colleges for every 1 lakh people. With at least 30 colleges per lakh people, the top 10 states in India in terms of college density are West Bengal, Rajasthan, Tamil Nadu, Madhya Pradesh, Andhra Pradesh, Gujarat, and Telangana. So it's a report that has come up from All India Survey for Higher Education. East Bengal crowned champions of Super Cup with thrilling win over Odisha FC. Kolkata heavyweight East Bengal were on Sunday crowned champions of the Super Cup after emerging 3-2 winner in a thrilling final against Odisha FC, with Chelton Silva scoring the decisive goal in Bhubaneswar. So it's a news that is coming from the sports segment. Now, World Leprosy Day 2024, it is celebrated on the last Sunday of the month of January. This year, the World Leprosy Day falls on January 28th, which is being celebrated on Sunday. In 1954, French journalist Rolf Ferraro established World Leprosy Day to celebrate, to campaign, to create awareness about this disease and explore the treatment options available that can provide the patients with a better life. The theme of this year, World Leprosy Day, is Beat Leprosy. This theme is chosen to beat the stigma associated with the disease as well as create awareness about it. ICC left suspension on Sri Lanka cricket. The ICC board on Sunday has lifted the suspension of Sri Lanka cricket with immediate effect. Now, Sri Lanka cricket was suspended in the month of November for being in serious breach of its obligation as an ICC member, in particular, the requirement to manage its affairs autonomously and ensure that there is no government interference in the governance. Later in the week, the Sri Lankan parliament had unanimously passed a resolution demanding the sacking of SLC. Parties from both the side of aisle had supported it. That resolution passed by Sri Lankan parliament seems to have irked ICC. The suspension meant Sri Lanka losing the right to host the ongoing Under-19 World Cup. Sinner winner, Italian takes first major at AO 2024. Jannik Sinner is a Grand Slam champion. The world number 4 clinched the Australian Open 2024 men's single title in stunning fashion, overcoming third seed Daniel Medvedev in the 3 hours and 44 minutes at Rod Laver Anera. He is the first Italian male or female to win an AO singles title in the Open era. Now, when it comes to the legal update coming from the Honorable Supreme Court, bail cannot be cancelled merely due to non-appearance of accused before the court. Supreme Court has observed that the non-appearance of the accused party is no ground for cancellation of bail. The High Court had noted that on several occasions, it directed the accused person to appear personally before the court. However, the court, while cancelling the bail, had observed that neither the accused nor his lawyer was present. And the case name is Krishna Sharma alias Krishna Kumar Sharma versus State of West Bengal. Now, it is related to Insolvency and Bankruptcy Court moratorium under Section 14, no bar to execute decree against directors, officers of corporate data. The imposition of the moratorium under Section 14 of the Insolvency and Bankruptcy Code 2016 has no effect on the execution of decree against the directors or officers of the company which is undergoing corporate insolvency resolution process. The bench held that the protection of moratorium under Section 14 of IBC is only available to the company and not available to its director or officers. And the case name is Ansal Crown Height Flight Buyers Association versus Messrs. Ansal Crown Infabuild Private Limited. Delhi High Court upholds prohibition of marriage between Subedars. So the Delhi High Court has upheld the validity of Section 5, Subclause 5 of the Hindu Marriage Act, which states that no marriage can be solemnized between parties who are related to each other as Subedars unless it is sanctioned by usage or custom governing it. Now, the court has given that this type of marriages will be void and will be nullity as if it has not happened anytime. And the case name is Neetu Grover versus Union of India. If you want to revise your previous TNA, do attempt the quiz link that is mentioned in the description box. Thank you so much for watching. Take care.